in the last 3 to 4 months, there were two major amendments or two major things which has happened. One is a notification on 24th of March 2020, and the other was an ordinance on June 5th. When it comes to notification, it essentially says the threshold limit, which was 1 lakh before to file an application, it was increased to 1 crore. I would say it is a welcome move for the simple reason that this particular section was misused. Everyone was using this as a recovery tool, whereas the intent of the law was to find out a solution for insolvency. So 1 crore is much better than 1 lakh for the simple reason that there is a process in it is called corporate insolvency resolution process. It is a very cumbersome and a very complicated thing. So for just a default of 1 lakh rupees, the corporate debtor is put to trouble. More than that, if you look at the in an MSME or a small company, a default, just because of a default of more than 1 lakh, if their entire process is sort of made standstill because of the corporate insolvency resolution process, the intent of the act will not be met. Therefore, I would say the increase to 1 crore is very justifiable. The next thing is the ordinance. Ordinance essentially says that the difficulty faced by the corporates, the companies, due to the economic sluggishness and the disturbances caused by COVID pandemic. So therefore, they decided to, central government says that they are going to suspend section 7, 9 and 10 for a period of 6 months. From which date? From 25th March 2020 for a period of 6 months or 1 year, up to 1 year. So why 25th of March? Because that was the date on which lockdown was declared. So the effect is, if a default which has happened after 25th of March for within 6 months or 1 year, let's use the word COVID period default. This particular default cannot be taken to NCLT ever. So the ordinance very clearly said no, it cannot. It can never. Filing can never be done. That, and ordinance also says that for the defaults before 25th of March, the provision will not apply. Meaning section 10A will not apply for those default which has happened before 25th of March 2020. And the time limit is 6 months or 1 year. Now another provision, which is section 66(3), it says that application under section 66(2) essentially talks about adjudicating authority, directing the directors to contribute to the company for certain acts. Let's not discuss about it. It is a very, since 10A is going to be applicable, so 66(2) is going to be a subset of that. So nothing grave about it. Now this comes with these two things come with a lot of confusions also. For example, this is going to be I would use the way misused by the people, and it will pave way for a lot of litigations. Number one, what constitutes the default amount? For example, the corporate debtors or the defaulters will always try to say that this particular default occurred due to COVID period or during the COVID period, so that this particular insulation they enjoy. For example, default of 75 lakhs occurred till 25th of March. Up till 24th of March, the default was 75 lakhs. And after the 6 months or 1 year, of course, they cannot apply under section 7, 9 or 10 if the default is less than 1 crore. So it will be lying asset. And after this 6 months or 1 crore, they have to again wait for another 25 lakhs of default to happen, if at all happens. Then only they can do. So end of the day, what happens is the value of stakeholders will again be lost. And a lot of interpretation can happen. Another challenge which I see is the conflicting judgments made. For example, in the case of NCLT Chennai, which is correct also, which says that any notifications or ordinance, it has to be prospective. based on that, in one of the cases, NCLT, Rockwell Industries case, NCLT has decided that this particular provision is proactive, therefore prospective, and therefore the case was admitted. In another case, where NCLT has actually admitted on 29th of May, and this was a small scale industry. Delhi High Court decided, it was taken by Delhi High Court, appeal was writ appeal, something was filed, and Delhi High Court says the intent of the enhancing of 10 lakhs to 1 crore was to support the MSME, therefore CIRP cannot be initiated. So they have stayed the proceedings of the NCLT. So there is a contradictory. I am sure this Pandora's box will be open. So likewise, this particular 2-3 sections, 7, 8, 9 will always come up with a lot of interpretations. Then there are 3 things which one needs to know is about the Supreme Court suo motu decision, which says effective of March 15, 2020, the limitations will apply. Therefore, it is an open-ended till such time further order comes up. So until further notice, they say, meaning so 15th of March till another order, the limitation they relax the period of limitation to all proceedings. An Insolvency Bankruptcy Board of India has come out with a notification which says section 40C says exclude the period of lockdown for the purpose of calculating the timelines. As I said before, CIRP is a very laborious and very complicated process. 180 days extended to 90 more days or 270 days, under whatever may be the circumstances, cannot be more than 330 until adjudicating authority says it is okay. 330 can also always be extended. Therefore, by this notification, IBBI says, Insolvency Bankruptcy Board of India says, under section 40C, to exclude the period of lockdown for calculating the timelines. And in between, NCLAT also come up saying that period of lockdown will be excluded for the purpose of counting the time taken for CIRP. So basically, there is a time-bound program. The lockdown period will be excluded from the particular period, which is rightly justified. Another thing is, which is hotly debated, is what will happen to MSMEs. Now, Section 240A, it comes out. Actually, it is a enabling provision wherein MSME has been given certain relaxations. For example, Section 29A talks about certain restrictions for resolution applicants. If a related party, they cannot come and they cannot come out with a resolution application. Certain restrictions are there. However, in the case of MSME, that restriction would not apply. Now, what happens is, with the new definition of MSME, with effect, I think it will be effective from 1st of July, almost a lot of companies will fall under the MSME category. So, resolution can be from the promoters even. So, 29A, which has put certain restrictions on the promoters with a, liberalized, criteria under MSME, I feel that MSME, the promoters, they themselves can come out with a resolution plan. Now, it is also said that very soon they are going to come up with a separate package for the MSME. We are all hopeful for that. We don't know how it's going to happen, but then looking into the character of the government, they may soon come out with that. We really don't know what is in the store. So thank you so much for a patient hearing, and please let me know if you have any clarifications. Thank you.